in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Hey folks, about 7 minutes ago, I woke up from, because I needed to visit the big boy's room. And I discovered that my DMs are shouting at me. I have emails. You need to wake up and cover this. Okay. Here is what I get from being in another time zone. Oh, crap hit the fan in the end of today. Wow. So let's try to get this in order. Ex parte info has been revealed, not the transcript, but enough for anybody who has spent an hour in law school or can read that, oh, Judge Glanville, you screwed up even more. Hello, everybody. I know I just came live, so I'm trying to find stuff as we go along. I already been sent stuff. First of all, Mr. Steele will not spend the weekend in jail. Okay? How do I know that? Well, because the Georgia Supreme Court says so. This is no longer in the hands of the Georgia Appeals Court. This is all the way up. So here is the docket search on Georgia Supreme Court of Georgia docket system. Filing and orders. Motion for state supersedes. The trial court order, exhibits volume 1. Judgments. Supersedes granted. All the justices concur except Peterson not participating. That means the motion to stay, the superseded bond is granted unanimously by the Georgia Supreme Court. Yeah, it's as Trinton says, appeals court rule. It's not for them because this was a murder count and referred it to the Supreme Court. They punted this all the way up. So, yeah, seriously, folks, this is going down, and it's going down fast. I said in my previous stream today, hopefully within weeks. I think this has put the Georgia Supreme Court on big alert. If it hadn't already done that, they received this filing. It says at 12 FMEDT, estimated date time. I have Eastern date time. I don't. Well, that's the filing to the. I think all three have that date, but they received it and they granted it. They must have been in a somebody made a conference call. I assume the Supreme Court clerk or something, and everybody was, oh, we need to meet, and we need to meet right now. They took a glance at it and granted. Okay, we need to be on high alert for this. So first of all, Mr. Steele does not have to spend the weekend in jail. Then this is part of come on. Part of what's going on. What actually was said. Oh, sorry. Yeah, subscribe if you haven't, by the way. There, that was the one. This is part of what happened in that ex parte meeting, which the judge told the court on the record had nothing to do with this trial. Upon information and belief, Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated she would not prosecute sworn witness Copeland if he were to lie on the stand. She was prepared to allow Woody, Mr. Copeland, to lie on the stand knowingly. This is far beyond any breach of all the ethics. This, if she is not, well, she should be reported to the state bar by now. And this, I don't see her keeping her bar card. Yeah, she is suborning perjury. I can't see her practicing law more than a few days. She's screwed. And she should be. Then the next point. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he is the one who ended Donovan Thomas Jr. That is the... And we heard this rumor. Now, in context, it seems like, well, I might as well lie on the stand and tell them I did it. Then, and only then, upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he ended Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. So that, if it's a lie, that she wouldn't stand. But here's the thing. What if it's true? And she would prosecute him for perjury, no matter if it's a lie or a true or the truth. This level of absolute corruption is astounding. It's astounding. And this is in front of the judge, which makes him a witness to this. That should have his bar card for allowing this to happen ex parte, and then try to conceal it from the defense. This is a Brady violation. This is exculpatory evidence for the defense. Now there's more. I'm trying to find as much as possible as we go along. Now, this, in my opinion, the entirety of this prosecution's team should walk. And here's the thing. If the junior prosecutors knows what's good for them, this is not a threat, not legal advice. They should testify against their bosses in the hope that that will save their bar cards, because now it's no longer an issue about if people are losing bar cards. In my opinion, it is how many of them. Yeah, Porcelain Thunder, I agree. This is mistrial with prejudice. I can't see how this survives the Georgia Supreme Court. Now, the Georgia Supreme Court can rule that judge, prosecutors, off you F. Off you F, off you fork. Off you fork. And then bring in a new team. But imagine with all this information, that anyone wants to touch this prosecution, even in corrupt Fannie Willis care. And she can't take it. She's too afraid to take it because, as you might not know, or you may know, Fannie Willis was YSL Mondo's defense attorney. And the only reason why this hasn't been revealed in court is because Judge Glanville won't allow it. So, yeah. Hey, MG Law. I'm going to send you a link if you want to pop in. Hold on. I'm still waking up, y'all. I'm still waking up here. I've been awake for a grand total of 12 minutes. Oh, so bear with me. I'm getting there. I'm getting there. Yeah, I showed that on my previous stream. He admitted a video into evidence that was clearly tampered with. You could see it with extreme time jumps in that video. Not, as you can see, a timestamp, but you can see a camera panning and then cut off, cut in, cut off twice in 17 seconds, and the judge allowed it. Yeah. Hello, everybody. Hit the like button. Wait a minute. Didn't I see something earlier? There it is. Cloak and Glomer for $5 bucks. Niklas, thank you for covering this corruption from the beginning. Thank you who have followed me, who have viewed my rants for a year now in this cluster clock of a trial. And thank you. Let's see. Woo! Hey, thank you. I have. I need to get myself a soundboard. But thank you so much for your support of the channel, Cloak and Glomer. Ooh. Yeah. Meanwhile, I can show you. This is the reasoning from the appeals court to punt it directly to the Georgia Supreme Court. Dun, dun, dun. Back to stage. There it is. Court of Appeals of the State of Georgia, Atlanta, June 12th. I mean, they received this. The Court of Appeals. They received it yesterday. Today, oh hell no, punting, and still the state, because this is a criminal matter because of Judge Glanville not knowing the difference between civil contempt and criminal contempt, and that he criminally tried to hide exculpatory evidence from the defense and holding an illegal ex parte meeting with the prosecutor where they coerced into forcing a witness to testify. Brian Steele filed an emergency motion in the Court of Appeals pursuant to Rule 40B, seeking relief from impending incarceration imposed upon him in connection with the trial court order holding him in criminal contempt. The Supreme Court of Georgia has determined, however, that if a murder count in an indictment remains pending below, jurisdiction lies not with the Court of Appeals, but with the Supreme Court. Specifically, if the underlying action is a murder case, the Supreme Court has jurisdiction of the appeal, regardless of whether the order being appealed is based on facts having some bearing on the underlying criminal trial. Although the appeal in this case arises from a collateral order of contempt, it is undisputed that the nature of the underlying action is a criminal prosecution. It follows that the emergency motion related to the order of contempt is a matter lying within the Supreme Court's jurisdiction. Bam, 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 bam. Stephen E. Well, the clerk. So there you have it. That's their reasoning. They are thanking the Lord they don't have to touch this. Can they bring in Judge Manning? I don't think he works in Georgia, does he? I don't know. Buran LLC, the Supreme Court gave Steele bond. Yeah, we just looked at it. It's here in the docket search from the Supreme Court, where the decision, now they have motion for stay, trial court order, exhibits. So this is already up there, and supersedes granted, all unanimously, and fast. Supreme Courts don't move fast, folks. Supreme Courts do not move fast. Oh, Manning is a Georgia judge. Oh, Judge Manning is in Fulton County. Okay. You know what? From what I've seen regarding Judge McAfee, I kind of like the guy. In some ways. Some ways not. I think that the other trial that is up and coming, maybe, he should have had the stay in place. But I don't think Judge McAfee likes Annie Willis. He supported her running for this position as district attorney, and that makes him look bad. Now let's find out, because I also know that Mr. Weinstein put in a motion. So we are going to see what went down at the end of today's trial. After everything. Hold on while I get it here. Share that. Share that. Sebastian Miller, thank you for being a member for 6 months. The judge in the Young Thug needs to be removed, like for real. Yeah, he has really stepped in it now. And the DA's office. I don't. When the dust settles after this fustercluck that appeared this week and Friday, I can't see this trial surviving. I simply can't, because now Friday, yeah, the Court of Appeals, the Supreme Court of Georgia, because judges like protecting judges, but when you, like Judge Glanville does, jumps into a pool of turds and throwing the turds around, they can't protect him that much without it rubbing off on them at this point in time. Friday, what happened Friday or on Monday morning, if the information hadn't been this bad. But now with everything that has transpired since Friday, and now I would assume when this is just one matter. You have the entirety of Judge Glanville's representation as a judge in this case is in question now. And not only that, because if Judge Glanville is prepared to do this here, the only reason we know about it is that Mr. Steele is not afraid of Judge Glanville. Judge Glanville can bark as much as he can. Judge Steele, Attorney Steele, already won against Judge Glanville. Twice, if my memory serves me right. Twice he have had Judge Glanville's decisions reversed. Or jury decisions reversed that Judge Glanville presided over. Twice. Yeah, this is not crap into a fan. This is the runs into a jet engine kind of situation. Yeah. And as Sebastian says, makes you wonder how much this has happened and how many people have been jailed because of this judge, if they were actually guilty or not. Yeah, I agree. And this is why this LawTube thing is so important. That the openness, first of all, cameras in court. This is why every court should have a camera. Every court. Because it reveals bad, corrupt judges and prosecutions. And while it might, for the layman to just watch, it is not. Now this is easy to understand. He done fucked up. He really did, royally. But in some cases, the corruptions sneak up on you, and us with a law degree who can spot this, who can interpret the rules, the laws, the statutes, that could help you understand more about the depth of the corruption. But let's listen here now. Yeah, Fenris. Yeah, I know. Drunk me bought this jacket for me because when I do my Finally Fridays and stuff like that, the casual streams with the Wheel of Regrets, sometimes drunk me gets on a shopping spree on sites like AliExpress and stuff, and then that doesn't show up until 6 to 8 weeks later, and then I have forgotten that what I've ordered. So I'm always surprised what drunk me gets sober me. Yeah, we left off at lunch. Drunk me, yes. Okay, he's still on the stand.
How did you start hearing of it?
And of course, there's the sidebar. Which brings us to sidebar counter 210. 210 sidebars since the start of this trial. 210. Astounding. Oh, John Commune, thank you so much. I wish I could give more. Don't give what you don't have. I'm a bad grifter at this. I'm really bad at grifting money out of people. I always say, don't give what you don't have. Thank you, John Commune, for your $20. Thank you. And for that, thank you so much. Thank you, it says, thank you for your work on this trial. Reward yourself with a shot this Friday. Thank you so. Yeah, it's just Thursday tomorrow. Friday afternoon your time, evening my time. It will be Sovereigns, Citizens, and Beer. That will be my stream. Depending on what's going on in this faster clock. Thank you. Yeah, and for you who haven't heard, Mr. Steele will not spend the weekend in jail. The motion to stay was punted up to the Georgia Supreme Court, and they granted the stay and the superseded bond. I will do a banner thingy. By the Georgias. There. Yeah, Miss Hilton. I'm not. Yeah, they played a video of him in an interview. I don't care anymore. Where is it? Ah, look at that. Another sidebar. Which brings us to sidebar counter 211. gentlemen. All right. We will be there soon.
Once again, reassert a motion for any Brady materials.
Maybe sometime into August, okay?
Okay.
All right. Ladies and gentlemen, we're in recess. I'll see you tomorrow morning, okay? All rise.
Okay. Now I see. Yeah. This was right after lunch. I just woke up, folks. I just woke up. Oh, Jesus Christ, what happened? Sebastian Müller gifted 20 memberships. You are a gem, sir. You are a gem. Hold on while I... Thank you so much. There. And it was gifted to Shanigram, Stirfrack Otter, Shay Go, Kelly Waller, Boom Her, Anastasia, Jordan Graham, Richard Martin, Emma, Linda Bönström, John Jones, Phoenix, Happy Annie, Andy Cakes, Denise Searles, Wawa, Semperfi Gert, David Nelson, Valhalla Waits, and Melissa. Thank you so much. Thank you so much, Sebastian Miller, for your very, very, very generous gift. That calls for wild cheering. There it is. Wild cheering. I need to get myself a soundboard where I can just play a button and all of that shows up. All right, let's listen to Mr. Weinstein's. Niniola, how do you become a member? Well, on top of the chat, you should see a gift box now. After Mr. Miller, gifted
My attention, Mr.
gifter memberships. If you press that, you will be given the option to receiving memberships. If you want to become a member without being gifted, it's on the dollar sign on the bottom of the chat. Or there should be a join button directly under the stream. If you have iOS, you have to get out of the app and into a web browser, apparently, because Apple, I don't know. Okay, but here we go. Let's listen to this.
Weinstein, you filed a motion to recuse me. You filed an affidavit consistent with that.
Yeah, Mr. Weinstein. Now, finally, it has been threatened or mentioned from defense attorneys. Now, there it is. Let's listen to how gracefully Judge Glanville takes this.
Pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular.
Here's the thing, Judge Glanville. You know what else you can't do? You have to give this to another judge. You can't make that ruling. Dave is using voice to text again. This should never comes up with an attorney trying to protect their client. Yeah. We went through this in my previous stream, how the rule, what the rules actually are. Because in criminal contempt against a lawyer, they have to weigh in the zealously advocating for your client. And did it halt the proceedings? And no, it didn't. The trial continued. So this judge really stepped in it. Hold on, I just noticed that my nicotine pouches isn't on my desk. Give me a few seconds and I will actually stop the camera for this because, as I said, I just woke up and sat down and started streaming, more or less. I may or may not be wearing pants. And it's not that I don't want YouTube to eat me, and I don't want your girlfriends to be knowing what they can't have.
Situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right, I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial.
Oh, I found the entire Mr. Weinstein's let's see here. Yeah. Mr. Weinstein is Diamante Kendrick's lawyer in this RICO trial. And I found, well, it's in the court, it's in the docket. So yeah, we will be reading exactly what's in Mr. Weinstein's motion for the judge to recuse himself after we listen to this.
And you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate, you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree.
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if you
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll
And that is Judge Glanville's. This is what Judge Glanville has been threatening with all along, because he knows appeal. If first of all, this trial will go unless the Supreme Court of Georgia says stop it, off you F, this is done. This would have we are at least a year away from the end of this trial. And getting this through the appeals court is years, if not a decade or more. And Judge Glanville knows that if it doesn't matter, he is in his 50s, late 50s, or something like that. I don't care. And once he retires, he doesn't care anymore. Hey, Niniola the Bay got a member. She discovered how to become a member. Thank you for becoming a member. You now have access to all my members-only content, which all of you who were gifted have as well, which is not so much about law. It's about me, the farm, the renovations, and personal thoughts and stuff like that. MG Law says it's probably like Florida and would result in concurrent jurisdiction. He could move forward with the trial, but if he's removed, then anything he does is reviewable by the next judge. Yeah. So what could happen here is give the certificate, then it's get punted to another jurisdiction within Georgia or within like Cobb's County. No, he really doesn't want to, because Cobb County, their district attorney, wanted to testify against Fannie Willis. Yep. Martin Curacao won. America is doomed with this kind of corrupt judges. Nation in decline. Yeah, yes. The justice system survives the worst defendants, the absolute worst defendants. The justice system survives bad defense attorneys. What it may not survive is corrupt judges and bad faith prosecutors, because they are the government. And if they decide to be corrupt, then the entire system is corrupt. Jesus Christ, there's a lot of you here. Hit the like button, subscribe if you haven't. There's over 1,000 people here. That only happened once before in my little channel. Thank you for being here. Let's keep listening. I have the actual Rule 25.3 lined up. I have Mr. Weinstein's full motion for Judge Glanville to recuse himself. I have all that lined up. Let's just listen to this.
I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court.
Oh no, Judge Glanville. Now here's the thing. Judge Glanville has been very threatening. He's known to send potential jurors to jail for misconduct. He sent Mr. Steele, or tried to send Mr. Steele to jail. His threats doesn't have any bear. This trial has revealed that the emperor has no clothes, or in this case, Judge Glanville has nothing left. His authority is gone. Arrow snivels. Oh yeah, thank you, moderator Ghost. If you don't want YouTube's to take 30% of your super chats, you can sponsor me via PayPal. I pinned the link on the top of the chat, but let's keep listening here.
Matter of professional responsibility. Remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility.
Look, oh, sorry. I said look at Weinstein, but you can't see him. Hold on. There. That is the posture of a man I don't give enough. That is the posture. Sure, Your Honor. Sure. But I'm not sure Judge Glanville knows how deep in trouble, what he dug himself into. This is Judge Glanville's image of grandiose about himself. He does not believe he did wrong. And that is why I'm actually happy that it's not the Georgia Court of Appeals that will be handling, that didn't handle the bond. They punted it to the Georgia Supreme Court. And I would assume if they believe this is better handled by the Georgia Supreme Court, they will punt everything up to them.
The obligations individually and to this court. And so I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding? I
am not at this point in time going to deny the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland?
Yeah. The way he starts to stumble his words at the end there, somewhere deep down he knows he forked up. Oh, hello, Patty B says he's downright threatening this lawyer. Yeah, this is Judge Glanville's signum as chief judge. This is what he does. If he doesn't get his way, he gets threatening. He's like a 5-year-old with a hand discovered with the hand in the cookie jar, throwing a tantrum. That's the only thing I can compare him with now. No, I didn't. And then he makes up law. Then he makes up rules. So let's check what Rule 25.3, which was the one that Mr. Weinstein addressed. Yeah. When the judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, which Judge Glanville actually said. He didn't contest what was in the affidavit. So he already made that finding. Hello, Phoenix, member for 5 months. Thank you. Whether recusal would be warranted. If it is found that the motion is timely, the affidavit sufficient, and that recusal would be authorized, if some or all the facts set forth in the affidavit is true, another judge shall be assigned to hear the motion to recuse. Judge Glanville did not deny what was in the affidavit. That, in pure lawyer speak, is him affirming what was in that affidavit. So he should, and it's clear in the 25.3, he should hand over that. He himself does not have the power to deny it, in my opinion. The allegations of the motion shall stand automatically. The trial judge shall not otherwise oppose the motion. In reviewing a motion to recuse, the judge shall. This is hard language. It is not may. It's not indiscretion. It is shall be guided by the canon of the Georgia Code of Judicial Conduct. Let's see if we can. Canon 3E. There it is. Let's see if we can. There. Canon 3. Dun dun dun. Hey, as I said, I woke up just minutes before I started streaming because I had to go to the big boys room and I didn't have time to put everything up in order immediately. Let's see here. Here it is. Canon 3. Judges shall perform the duties of judicial office impartially, competently, and diligently. Was it 3.1? Hold on. Canon 3E. E. Where is it? Where is it? Disqualify and recusal. E. It should be here somewhere. See. What? Oh, let's just go through it. Okay. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Might. That's the standard, might, which is if the judge affirms that the affidavit, what the contents of the affidavit is correct. There you have it. But this judge simply won't do it. Judges should disclose on the record or in open court information that the court believes the parties or the lawyers might consider relevant to the question of disqualification, even if they believe there's no legal basis for disqualification. We didn't hear him do that. No comments whatsoever. Yeah, but let's go here. Hold on. This is Mr. Weinstein's full motion for the judge to recuse himself. Can I make it a bit bigger? Yeah. State of Georgia versus DeMonte Kendrick, which is Mr. Weinstein's client in this trial. The defendant, Mr. DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to recuse Chief Judge Ural Glanville from continuing to preside over the present case and request that the present trial be temporarily halted until the present motion is heard by another judge of the Superior Court consistent with the uniform rules of the Superior Courts of the State of Georgia, stating the following, quote, "It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges. And judicial recusal serves as a linchpin for the underlying proposition that a court should be fair and impartial." I have, ladies, gentlemen, and whatever you identify yourselves as, been shouting from the rooftops for months about the bias of Judge Glanville. The absolute bias of Judge Glanville for months. And this now, when everything is getting up to the light and you see the big channels are covering this, I was right all along. I was right all along. Yeah, we will get there, Obi. We will get there. And how it happened. The present case involves a 65-count RICO indictment against 28 individuals. Yeah. 65 counts RICO indictment. That doesn't take into account that in the RICO charge alone, there are 196 underlying and overt acts. This is how huge this trial is. Jury selection began this. Given that the state had presented less than half of its current witness list, which the state has announced could be increased based on the circumstances, the trial should last well into 2025. Yeah. The 6 defendants presently on trial, including Mr. Kendrick, has been denied bond and incarcerated for over 2 years. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. On Friday, June 7th, Kenneth Copeland was sworn in. Despite being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, or that is a faster clock of his own, because I cannot fathom why a local prosecutor handing over, I will grant you immunity, erases the Fifth Amendment. I just can't have that. I think it's stupid, but that is the current statute. Copeland was ordered incarceration by Chief Glanville on that date, and Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, where Copeland would announce whether he was prepared to testify. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m., admitted entrance, and seated within 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Attorney Brian Steele, counsel for defendant Mr. Williams, inquired with the court as to the delay and what have occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. Unknown to any number of defense counsel during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Chief Judge Glanville's chambers. Among Chief Judge Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. So, in that room was the entirety of the prosecution's team. All of them knowing they had an absolute obligation to turn over any exculpatory evidence, possible exculpatory evidence to the defense, together coerced Mr. Copeland into testifying. And they didn't reveal the contents of that meeting, even though. So, yeah, this is going to be a squeal match. Whoever wins first of the prosecution's team might get to keep their bar card. That is my prediction. No member of defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. Upon information and belief, neither Chief Judge Glanville nor any member of court staff nor the Fulton County DA office made any member of defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during, or after. Now, here you can see the information and belief. Glanville, not the court staff, not the DA's office. That only leaves either Mr. Copeland himself or his attorney, who chose to reveal the information to Mr. Steele. Copeland briefly testified prior to lunch recess. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and was aware that at least some of the content and subject matter of the ex parte meeting Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in the chambers of Chief Judge Gerald Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify in that meeting. Upon information and belief, Copeland stated he would sit in jail for 2 years rather than testify. Upon information and belief, Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. For you who don't know, there's people waiting the result of this trial, whose trial of their own, because they are severed from this RICO case. They are also in jail or out on bond awaiting trial, which will not happen until after this trial. So this is Judge Glanville threatening Mr. Copeland with, this is not just 2 years. This might be 5 years or 6 years. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Yeah. Upon information and belief, following the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated that at the ex parte meeting that he would testify. Upon information and belief, Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Yes, Aroris thought. This is brand new. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that he would not prosecute sworn witness Copeland if he were to lie on the stand. Do you have any idea how serious this is? This is ADA Hilton telling a witness who is sworn in under oath that you can lie on the stand if you want to. I won't prosecute you. This is, Hilton should, Judge Glanville, Hilton, Love. Those 3 should never be allowed to enter a courtroom ever again unless they are defendants. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. That is the admission we all have been hearing about, that he confessed. Now, in the context of this, it might be that, well, if you're giving me immunity, even for lying, I might as well say on the stand that he killed Donovan Thomas. Here's the thing. We can't tell if it's a lie or if it is the truth. Neither can the prosecution. Neither can the judge. That is why this is a Brady violation. This is why the information should have been held. This is possible exculpatory evidence. This is the big central point of this trial is the murder charge, because murder does not have a statute of limitation. And if that's gone, then all the other charges, their statute of limitations apply. Selling drugs in 2014, 2015, gone. Car theft, gone. Home invasion, Gone. Almost the entire RICO case, if the murder charge does not stand, is gone. And that, I believe, is why in this part of the RICO trial, the prosecution and the judge are colluding together, because they know if they get any information in front of the jury, if any information reaches the jury that somebody else confessed, it's gone. That charge is gone, and with that, the entire RICO case. Upon information and belief, in response to sworn witness Copeland stating to Hilton that he would testify that he killed Donovan Thomas Jr., Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. She's not saying we will send that off the investigation, and if we find out that you are lying, then we will prosecute you for perjury. No. If you say this without inquiring if that might be true, she was prepared to prosecute him for perjury, regardless if it is true or false. I will post a link to the document at the end of this stream. During court, the afternoon of June 10th, when more and more above allegations were presented to the court by Attorney Steele, Chief Judge Glanville denied that one or more events above relayed to him were accurate. Well, I'm not entirely sure about that. In my opinion, what Judge Glanville said or tried to avoid saying is that it's all true. That is why he focused so hard on who told Mr. Steele. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proof, would warrant the assigned judge's recusal for the case, Mondi v. Magnolia Advanced Materials. And here he goes through the present motion for recusal is being timely submitted. And it is. They, once they learned, shit went down. Shit went down. Hard. The present motion includes a sufficient affidavit demonstrating the need for recusal. Yeah, it does. It does. Recusal is warranted based on the facts alleged in the Weinstein affidavit. Yeah, recusal is warranted, in my opinion. And here is one of the good things. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures that every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communications are presumed to have been in error, and this is the case law. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland into testifying. And here is, quote, a trial should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. Win v. State, Benton v. State. And I mean, the reason, this is 1938 and 1976, the reason why this case law is so old, it's because it never happens. Or in Judge Glanville's case, nobody has called him out on it until now. Yeah, no reply. Fannie Willis is good friends with Wilder, says Mondos. And and Fannie Willis represented YSL Mondo while they were. Well, that is an allegation that they both say didn't happen. But if you would add, if they would ask Mondo now, he might say they did. But it's true that Fannie Willis represented YSL Mondo. She was his appointed defense attorney. And it's my theory that the entirety of this RICO case is based on information Fannie Willis got from YSL Mondo at the time she represented him. In my opinion, she violated attorney-client privilege in order to get this RICO case to happen. Let's continue. As the Georgia Supreme Court wrote, we need not decide whether such bias or impartiality actually existed, because judges are ethically bound to disqualify themselves whenever the impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she, quote, has personal bias or prejudice concerning a party or a party's lawyer. Johnson v. State. Defendants were not provided notice of the hearing either before, during, after, and regardless. Defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state as sworn witness Copeland was to harass and intimidate the sworn witness into testifying. Z for 20 Norwegian krona. Does Georgia have the death penalty? Yeah. Or let's see here. U.S. Supreme Court reinstated the death penalty in 1976. Georgia resumed executions in 1983. Last execution was in January 2020. At the I remember that. Pie. Yeah, Willie Pie in 2020. Thank you for your support of this channel, Z. Thank you so much. Given that the facts as alleged must be assumed to be true, that Weinstein affidavit is sufficient and that recusal would be authorized under the alleged fact, another judge should be assigned to hear this motion to recuse. But as you heard, Judge Glanville refuses, because he knows the moment another judge takes a look at this. Because in my opinion now, Judge Glanville's authority is gone. It is. It is simply gone. What the? I'm trying to get a. Yeah, let's get back to this. Wherefore, Mr. Kennedy respectfully submits that the present motion meets all requirements of U.S. CR 25.1, 2, and 3, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse, Mr. Kennedy requests that the court makes specific factual findings and submits that Chief Judge Glanville should voluntarily recuse himself. And as you heard, Judge Glanville refused. He is ethically bound to do this. This is in the rule book. He has to, but he refuses. Should the court take neither of the above action, Mr. Kendrick moves this court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review, which the judge also denied. Yeah, from no reply, Fannie Willis has filed a motion to the Georgia Court of Appeals to dismiss the appeal of the disqualification motion brought forth in the Trump RICO. Yeah, I know. That is for a separate stream where I will go over that. Respectfully submitted by Mr. Weinstein. And this is simply the suggestion from Mr. Weinstein that just sign, Your Honor, and this is all done with. Certificate of service. And here is Exhibit 1, which we already went through. It was, yeah. And upon, yeah. And so Mr. Weinstein took his name to this affidavit. He is now putting his bar card on the line. This is the line in the sand. That was drawn by Mr. Steele on Monday. Tuesday, Monday. And the rest are following. The rest are following. Yeah, this shows so much desperation from Judge Glanville, because he knows he can't cite case law, he can't cite the rule. He simply states orally that he's a jackass. No, he doesn't. He simply refuses because he can't. He simply can't, because he's wrong. His decisions are not supported by law, by statute, by ethics code. His conduct in this trial has no legal support. This is faffle. F around and find out. And I can almost guarantee y'all that Judge Glanville has done this with the prosecution on numerous occasions. But Mr. Steele would not be bullied into submission. And now things are going down hard. I would be surprised if there are criminal repercussions because of this. But I would assume that bar cards are being revoked after this, because the Supreme Court of Georgia, which is handling the appeals now, will, because if they find that Judge Glanville did no wrong, the precedent that would give to the entirety of Georgia is too far-reaching. If they still do, then they also say that Mr. Steele's conduct warrants his bar card, that all the defense attorney's bar card should be revoked. Yeah, this is not crap hits the fan. This is the runs thrown into a jet engine. This has repercussions on the entirety of the Georgia judicial system. It is unheard of. And all because District Attorney Fannie Willis wanted to become the next Attorney General of Georgia. These RICO trials were her stepping stone in her political ambitions, becoming the Attorney General. You don't get to Attorney General by home invasions and the day-to-day crimes, solving those. You get there by big publicized trials, which is the RICO trials against Young Thug, the RICO trial against former President Trump, and the other 3 RICO trials that has been going on and are ongoing. Thank you, Ghost, but I can't say I have unbiased commentary about the YSL trial, but I do apply the law as I understand it. I don't practice in the United States. I do labor law over here in Sweden. But I do have a law degree. I know how to interpret evidence. I do know how to evaluate witnesses. I know how to read fucking rules. And what else can I say? The crap really hit the fan. Spreche ich mit Deutsch? Keine. I haven't spoken German in quite some time. I haven't had a case in Germany for a good 15 years. Give me a month and I would be roughly fluent in it. Yeah. For you who don't know, hi, I'm Nick. I'm the one without the white powder on the nose. I have done labor law for over 30 years. I spent 3 years in the European Parliament as a documents analyst. I've been doing this a long time, and I'm very good at it. Ooh. Now it is 2 a.m. where I am, and I was just up to get a piss. And here I am at 2 a.m. and my alarm bell goes off at 4:30 a.m. because this farm doesn't run itself. Yeah, so what can I say? I will see you tomorrow, your time, because there will be more information out there on the grabs. And I have all day at work to occasionally search for it. So we will see if the judge will be, because now today Weinstein filed it. Today, first of all, the motion for bond, supersede bond, was filed yesterday. It was punted this morning, and today the Georgia Supreme Court came to the conclusion, yeah, he is out on bond. So, yeah. Thank you, everybody, for showing up. Join me here again tomorrow, your time, where any kind of information I find out, I will share with you. Oh, thank you, Snivels, for gifting 10 memberships. Woo! Thank you. Thank you so much. All right. And it went to K-Mac Red Queen, Sadie, Just Cause, Alexa Muted, Kommer Z, Jody, Christina Bingham, WV, Dime Philly Diva, Rossman Ranch. You now have access to all my members only content. You too. Now I really have to make an off I fuck motion towards my bed because Jesus Christ, I'm tired. Thank you. Thank you for allowing me to do this. You guys are the reason I do this. You showing up day after day. You who showed up for the first time, welcome. I hope to see you again tomorrow and the subsequent days. Watch my other content. Give me a thumbs up. Subscribe if you haven't. But now I really need to get to bed because Jesus Christ. I will see you tomorrow. Thank you so much. Hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Bye-bye.
In the courthouse where time stood still, generations pass on the hill. Prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's split tight as a vice. In this endless trial we pay the price.